everybody. Good morning. We've got an early morning one this morning. How's everybody doing? Okay, so we got some new documents here. Good morning, everybody. Please smash that like button on your way in. Let everybody know that we are live. Just finishing getting everything set up here. Good morning. Hello, Kim. Diana, hello. Please smash that like on your way in. This is a little quick live. Good morning, Kate. We got some new documents that have been filed in the Lori Vallow Chad Daybell case. So I just seen these late yesterday afternoon, so I decided I would do the live this morning. Give you guys time to have a good night's sleep before we go over all of this. Good morning, everybody. Good morning, Kate. Okay, so let me just get these documents up and then we'll get started. Please smash the like button on your way in. Let people know we're live. And it helps too because then I don't have to keep going over these documents once we have seen them. Okay, so here's the first one. Let's give it a couple minutes. Good morning, everybody. Let's just give a couple minutes for everybody to get in. How is everybody this morning? Okay, let me just get my ducks in a row here, you guys. Good morning, Just Sherry. Good morning. Thank you, everybody, for smashing that like. Lets everybody know that we are live. Make sure, too, you guys, you've got live chat selected at the top of your chat so you don't miss anything. Good morning, Scottish Lass. Diana, good morning. I'm great. This is early morning for me, so I'm on the East Coast, so I don't know where all you guys are from. Scotland, I know you guys are probably late morning, early afternoon now. Diana, I hope you're good too, my dear. Good morning. I still haven't finished my morning coffee yet, so if you guys want to grab yourselves a coffee, we're going to get going on this. Good morning, Nancy. Just Sherry, Kate Bell, Diana, Yellowstone Mandy, K Mitch. K Mitch is grabbing herself a coffee. Good show. Good morning, Roberta. Good morning. 1:30 in the afternoon, Scottish Lass says. Good morning from South Carolina. Hope you guys are all getting better weather than we are. It's cold here up in the north. Thank you, everybody, for smashing that like button. It's getting word out there that we're live and we can get going on this. Okay, so let's get started on this one, you guys, as people are coming in. Good morning, Candalee. Oh my gosh, Candalee says it's 5:30 in the morning where she is. That's about the time I was opening my eyes and figuring out if I really wanted to get up that early. Just Sherry says 8:30 a.m. You're on the same time zone as I am. So we've got some interesting stuff here. This one really isn't a shocker to us. Lindsay Blake filed this. You can see up top here on the 2nd. And this is their notice that they are going to be seeking the death penalty for Lori Vallow also. We know that Chad Daybell, in his part of this case here, they've already filed the notice to seek the death penalty. Sherry says, I'm in Maryland. So this is just brief, you guys, just to let the courts know that they are going to be seeking the death penalty. Her lawyers basically seen this coming long ago. So it says the state of Idaho, by and through the Fremont County Prosecutor's Office, hereby puts the court and the defendant on notice pursuant to Idaho Code 18400 that the state will seek the death penalty against Lori Vallow, aka Lori Daybell, in the event of the defendant's conviction for any of the counts of first-degree murder and or any of the counts of conspiracy to commit murder as charged in the indictment. Good morning, Joan. From Portugal. Wow, good morning. Yep, I guess the porta potties are still broken. Further, the state will rely on one or more of the following statutory aggravating circumstances as the basis for seeking the death penalty under Idaho Code 1925-15, subsection 9, as follows. So for the murder of Tylee, Ryan was committed for remuneration. The murder of JJ Vallow, same. The murder of Tammy Daybell. The murder of Tylee Ryan was especially heinous and atrocious. And it's the same for JJ and Tammy. By the murder or circumstances surrounding their commission, the defendant exhibited utter disregard for human life. The defendant, by her conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited propensity to commit murder, which will probably constitute a continuing threat to society. So there is why they are seeking the death penalty in Lori's case. And this is the second filing. I also have the filing, the order, you guys, for the cases being both moved. Now, this is where the fight is going to be. Both cases, I got notification from Vine. Let me just, before we get into this, let me just see if I can find that first. Okay, let me just move that over here so I can show you guys. Okay. So this was for Lori. That, as you can see here, the case status is now open. This used to say stayed. Go to court records and we get court events. And as you can see here, okay, so we have a motions hearing coming up May 19th. I don't know if I have that written down. Let me just see. No, I don't. So let me get this one written down, you guys. Just bear with me. I want to make sure I've got this, all their hearings written down, because I believe that we can stream that one. Good morning, everybody coming in. Good morning, Corey. Good morning, Robin. 10:30 p.m. at night in Australia. Summer Dawn, good morning. Candalee, good morning. that's what we're going to go over, Candalee. That's what we're going over right now. Yes, it is. Very nice to see everybody from all over the world. Okay, so this is what I got. The trial was going until December 16th, starting October 11th. If we go through here, you see here October 18th, September 6th was a pretrial. Let me see, make sure I've got that. I do have that one. But this starts back in October, coming up in October. I can go through this. It will show. So where do we got that? September 6th, pretrial. But the trial was scheduled to start, and you can see here again, December 16, 2022, jury trial, location, Fremont County Courthouse. So as far as I was concerned, I got this from Vine, and that her trial was going to be held at the Fremont. You can see it right here, the Fremont County Courthouse in St. Anthony. And it was a jury trial. Her jury trial is scheduled to start October 11th. And as we know, these trials are joined. And there's already been a trial date set for Chad starting January 9th in Ada County. Okay? So when I got this from Vine, I also got the exact same thing for Chad starting January 9th. The date up here would have been January 9th. And it said jury trial, Fremont County Courthouse. So I said, perfect. Both trials are going to be held in Fremont County. I put that tweet out about a week ago. So since then, the judge made a decision that the trial was going to be held in Ada County. So this has now all changed. Now there's a problem that we have, and we're going to see that in the next court filings that I'm going to show you. And this is why now there is going to be a motions hearing on May 19th. When Lori was found competent to stand trial, she did not waive her right to a speedy trial, which means they have to get her to trial within 6 months. That's why her trial is scheduled to start October 11th. She is entitled to ask for a speedy trial, and by law, she is entitled to that speedy trial unless she waives her rights to a speedy trial. So, as it stands right now legally, they have to get her into court and into trial within 6 months. This poses a problem for the prosecution and for the courts because their trials at this point are still joined. I believe that's why this motions hearing is set for May 19th, because Lori's team is not going to agree to having this trial put off to January 9th. She is entitled to a speedy trial, and she wants her speedy trial. So I believe, and this is only my opinion, like I gave last month, and I'm going to show you that. Where is it? Right here. If you remember, last month, before we got wind that Lori was brought back to competency, I put out this on my Facebook under the community tab. Okay, so this is before we got any documentation or anything. I put out there, Lori Vallow, could she be heading back to the jail? Lots of sealed documents and hearings have been happening along with subpoenas, 3 to be exact. Her last 180 days is up as of last week. And generally, we have heard quickly if she was still not competent. So during the last 2 extensions that she got with the evaluation, we heard pretty quickly that she still wasn't competent. With her 180 days being up, that gave me indication right there that they had brought her back to competency, because we didn't get that notification that she was still not competent. There was nothing filed legally, but when you're used to working in cases like this, as you guys know, I worked in the criminal law for many, many years. So when I seen this, I knew. And people were saying, oh, you're wrong, she's still incompetent and blah, blah, blah. And I said, no, I believe she's been brought back. And that's why I posted this. So I do believe she will be heading back to face the charges. We'll keep an eye on this for sure. Sure enough, she had been brought back to competency. Okay, so which brings us to this. Where was I before this? Yeah, here in Vine Lake. So, being that she is entitled to a speedy trial, they set her trial date to start on October 11th. Like I said, this has now posed a problem for the court and for the prosecution, because as right now, their trial is still joined. So, the courts have a couple of things that they can do here. They can move Chad's trial up to have it together with Lori's on October 11th. They can separate the two, because Lori is entitled to her speedy trial, and have two separate trials. Or they can try and force Lori to go ahead with her trial in January along with Chad. Now, there's going to be a lot of fighting about that, because the defense for Lori is going to want their speedy trial. They are not going to agree to wait for her trial until January. So, in other words, I think if this is forced and they fight it, then there's going to be some problems. We're going to end up with two trials. At that point, I believe that Lori would try and make a plea. So if anything's forced on her, I think she would try to make a plea. Good morning, Jean. Brenda. Morning, Brenda. Jean. Okay, so let's get back to the document. So, I just explained to you the three things that could happen. We do know now. Good morning, Mandy. We do know now that the prosecution is going to be fighting to have this Lori's trial pushed to January. I am going to be watching very closely for documents being filed from her attorneys into the record. And as soon as I have that, I will bring that to you guys. Okay, so this is 13 pages, you guys. So let's... Good morning, Jamie. Good morning, good morning. Thank you for being here. Yeah, I think she's been competent for a long time. Okay, so with that being said, the prosecution, they're not idiots. They see what is, Lori's attorneys are trying to do here, probably in cahoots with Chad's attorneys. This is a way for them to get the trials severed. They're calling it improper severance. And this would sever the trials, because John Pryor has already complained that having the trial in January of 2023 is just too soon. He wanted it late 2023. I think it was like October or something of 2023. He said he wouldn't be able to be ready until then. So, and the court said that's way too long to put it out. So they set it for January 9th. 2023 is when the joined trial is supposed to go ahead. with Lori being brought to competency for those just joining. She did not waive her right to a speedy trial. Her trial date has been set for October 11th. By law, they have 6 months to bring her to trial. So this is why the prosecution is now filing this document. They're claiming that this would be an improper severance, because they would have to sever the trials at that point to have them separate. Either way, I think that Lori may plead out. But let's go through the document. And welcome everybody joining. So the state filed this just 2 days ago. So this was put into the record yesterday. So that's why I said I would bring it to you guys today. Good morning, Sammy. Good morning. Thank you for being here. So this is for Lori's case, motion to find good cause to continue trial and prevent improper severance. The state of Idaho hereby files this motion to continue the October trial setting in the above captioned matter and the October date for the companion case 22-21-16-23. While this court recently entered an order setting a trial in the above captioned matter to begin on October 11th, 2022, this court has repeatedly found and held that these cases are one for trial. Good morning, Celtic. It is improper to continue the October trial setting for both defendants' cases and restore. It is proper, sorry, I thought it said it is improper. It is proper to continue the October trial setting for both defendants' cases and restore the prior trial date scheduled to commence on January 9th, 2023. Oh, Jean, thank you for that. Yeah, Barry is still going to court. He has a court date coming up nearing the end of May, and those are for the casting that vote for Suzanne. So I don't know if we're going to be able to see that, but I will let you guys know what happens in that. And I'm still very closely watching that case also, because I do believe those charges are going to be brought back. And we know that Judge Lammer, for those of you who don't know, sorry to get off topic here, with Barry's trial, Judge Lammer has resigned as a judge. So Judge Lammer will not be hearing that trial when it's refiled. Sammy, we're going through the paperwork now. You're very welcome, Jean. Okay, so this court has repeatedly found and held that these cases are for one trial. It is proper to continue the October trial setting for both defendants' cases and restore the prior trial date scheduled to commence on January 9th, 2023. If both cases are not set for trial at the same time, it will result in improper severance. Okay, let me just check, you guys, while we're doing this, to see if John Pryor has filed anything as of today regarding this. So far, there's nothing. The order came back, though, for Chad, for that motion to dismiss his indictment. The judge came back. It was denied. So that's the only other thing that's in there. We knew that was going to be denied anyway. But John Pryor has not submitted nothing regarding this yet. Okay, so let me get back to this. Factual and procedural background. So we can see here, you can see that there's a footnote here. That footnote is during off-the-record discussions. So those are things that we would never hear. between the court and counsel, the court reiterated this is one case for trial and that a trial scheduling order for the October date would be entered in the companion case number CR 22 1623. Let me just check this. And that is Chad Daybell's case, I believe. Let me just check. Yeah, that's Chad Daybell's case. They made a mistake there. But anyway, it doesn't matter. But yes, that's Chad Daybell's case. So, by the sounds of this, Chad Daybell's case will be moved to October 11th. Yeah. So that's why I just checked to see if John Pryor has filed anything yet. Pryor always looks like he's going to blow a gasket. Yeah. So this was done off the record. Okay. So John Pryor has been made aware that his case is not going to be starting now in January. It's going to be starting in October. I'm sure he blew a gasket. I will be watching for his responses to this. So on April 16th, 2021, a grand jury was convened in Fremont County, Idaho. On May 24th, 2021, that grand jury returned a joint indictment against the defendants, Chad Daybell and Lori Vallow Daybell, containing a total of 9 criminal charges relating to the murders of Tylee Ryan, JJ Vallow, and Tammy Daybell. And don't forget, Lori is still facing a charge of murder in the death of her ex-husband, Charles Vallow. That's in a different county, though. That's in a different state. So once she's done with this, she's still going to be facing that, okay? Specifically, the indictment, good morning, Glamady. Just Sherry, good morning, good morning. Yes. Good morning. Okay, specifically, the indictment charges both defendants with 1 count of conspiracy to commit first-degree murder and grand theft by deception, wherein Tylee Ryan is the victim. 1 count of first-degree murder, wherein Tylee Ryan is the victim. 1 count of conspiracy to commit first-degree murder and grand theft by deception, wherein JJ Vallow is the victim. 1 count of first-degree murder, wherein JJ Vallow is the victim. 1 count of conspiracy to commit murder, wherein Tammy Daybell is the victim. In addition, defendant Lori Vallow Daybell is charged with 1 count of grand theft, wherein the United States government is the victim due to Vallow Daybell receiving Social Security funds intended for the care of Tylee Ryan and JJ Vallow. Defendant Chad Daybell has additional charges of 1 count of first-degree murder, wherein Tammy Daybell was the victim, 2 counts of insurance fraud for the receipt of life insurance proceeds for Tammy's death. Defendant Vallow Daybell previous counsel Mark Means requested a competency evaluation in prior case 22-20-838. That's for not producing her children. The court entered an order for competency evaluation on March 8th, 2021, and following its review of the psychological assessment, determined that the defendant was incompetent to stand trial on June 8th, 2021. Remember, that was the original trial date. On June 9th, 2021, this court entered an order staying the case in the above entitled matter pursuant to the finding of incompetence and commitment of Lori Vallow Daybell to the state hospital. On September 22nd, 2021, an order for extended commitment was entered following a progress report from the state hospital on restoration efforts. Okay, so like I said, each time she came back from the time given for an evaluation and then the extended time that was given, there was always an assessment that came back that she still wasn't competent. So on April 11th, this court entered an order finding the defendant, Lori Vallow Daybell, fit. Okay? Do you remember this that I posted? I posted this, I believe, on, you go back 3 weeks, and it brings it to, I believe this was on the Monday, the 16th. And we did not find out, or was this on the 13th? It was either on the Friday or the Monday. The 11th was on the Wednesday. Oh, wait. Sorry, you guys. I'm looking at the wrong date here. The 11th was on a Monday. So, yeah, I believe it was the Thursday. But when I posted this, it was when her 180 days was up. As of last week, and generally we have heard quickly if she was still not competent. During the last 2 90-day evaluations, we heard very quickly that she was not competent yet, but we still hadn't heard yet. So that's why I said I do believe she could be heading back to face the charges. And then it was just days later after this that we got notice that she was found competent. And that was on the 11th. So, anyway, I've called it pretty close. So they found that she was fit to proceed and lifting the previously entered stay. On April 19th, the defendant, Lori Vallow, was arraigned and pursuant to her request for a trial setting within statutory speedy trial limits, her case, along with her co-defendant, Chad Daybell, was set for trial commencing October 11th. So this is where it's different from Canada and the States. Because she did not waive her right to a speedy trial and her trial is joined with Chad's, that automatically set Chad's trial date to October 11th also. Okay. And her trial, as I showed you in the Vine, was originally set to happen in Fremont County starting October 11th. Now, since this date here, since April 19th, I believe it was just, I'd have to go back to the Vine. Because then I started getting notices that it had been changed to Ida County, and that was just a few days ago. So the judge, after this date was set, the Vine notifications went out that their trial was going to be in Fremont County. And then just late last week, Vine messages went out again saying, nope, the judge came back, made an order that it's all being moved to Ada County. The prosecution fought that and lost. So this is going to be held in Ada County. So Lori's right to a speedy trial that she wanted in Fremont County, she did lose that part of her speedy trial, but it's going to be held in Ada County. So the law and argument. In Idaho, criminal cases are governed by constitution and statutory considerations regarding speedy trial rights. The right to a speedy trial is guaranteed by the Sixth Amendment to the United States Constitution. So it just goes through the constitutional rights here. Good morning, Shelbell. Good morning, Trudy, Vera, just Sherry. Good morning, everybody coming in. So if you do want to read this, you can read it if you like. But it does, the relevant part of Idaho Code 193501 provides that the court must order that a prosecution or indictment be dismissed if not brought to trial within 6 months, unless good cause is to the contrary is shown. The state bears the burden of demonstrating that good cause exists for delay of a trial beyond the 6 month statutory prescribed time period. So then they bring up other cases in the state versus Clark. The Idaho Supreme Court took the opportunity to analyze what constitutes good cause in relation to the U.S. Supreme Court's 4-factor balancing test. And they are bringing these cases to light. Okay, so the court adopted in the Barker versus Wingo, the court adopted a balancing test in which the conduct of the defendant and the prosecution were to be weighed and identify 4 primary factors the court should evaluate in determining whether a particular defendant has been deprived of a speedy trial right. The length of the delay, the reason for the delay, whether the defendant asserted the right to a speedy trial, and the prejudice to the defendant. Ultimately, the Clark court, sorry, it's very early in the morning. Good morning, happy days. Decided that good cause could be determined by an examination of the reasons for the delay and concluded good cause means that there is a substantial reason that rises to the level of legal excuse for the delay. The ultimate question of whether legal excuse has been shown is a matter for the judicial determination upon the facts and circumstances of each case. In evaluating whether there is good cause for the delay, the trial court is instructed to consider and apply different weights to different reasons. Our speedy trial standards recognize that pretrial delay is often both inevitable and wholly justifiable. Internal citations omitted. We attach great weight to considerations such as the state's need for time to collect witnesses, oppose pretrial motions, to locate the defendant in the event he or she goes into hiding. Further, the length of the delay is a triggering, oh my gosh, you guys, triggering mechanism unless there is a delay that is presumptively prejudicial. An analysis into the remaining factors in unnecessary. However, the nature of the case is also relevant in determining the period of delay that can be tolerated. For the period that is reasonable for prosecution of an ordinary street crime is considerably less than for a complex conspiracy charge. Typically, courts have looked at the reasons for the delay in relation to unavailable witnesses, newly discovered evidence, or issues that arise much closer to in proximity to the trial date. The reason for the delay in Risden was due to an unavailable lab witness. In Clark, however, the witness was not found to be truly unavailable, and the rest of the delay was attributed to the congested court calendar. In Risden, the court found good cause for the delay, while the Clark court dismissed the case due to the speedy trial violation. No, there's never just one trial with 2 juries. No, it'd be 1 trial, 1 jury. The court should find good cause to continue the trial date as the reason for the delay arises to the level of a legal excuse and the length of the delay is short in retaliation to the complexity of the case. Defendant Lori Vallow Daybell's case is uniquely positioned as good cause arguments are being made shortly after arraignment and months before issues relating to witness availability, evidence testing, notice of affirmative or mental illness defenses, full full exchange of discovery or argument of all pretrial motions have occurred. The state asserts this fact in itself constitutes good cause. As noted above, great weight should be attached to the time needed to address full exchange of discovery, litigation of all pretrial motions, and collect witnesses. This is even more true in a case of this complexity with voluminous discovery and with the added complication of arranging trial logistics in a different venue. Further, co-counsel for Vallow Daybell has only recently been appointed, and the time to digest the status of the case, pretrial motions filed by former defense counsel, and review discovery has been limited. So here, they're trying to, what they're trying to do here, and this, don't forget, this is the prosecution. They're trying to say, well, the defense isn't going to have time to go over all this. The defense isn't going to have time because there's a newly appointed attorney. The defense isn't going to have time, blah, 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 blah. It's like, wait a minute. The defense has said they're ready to go. So you see what's going on here? The defense, the prosecution is trying to put arguments in there for the defense, because the prosecution doesn't want this severed. And I think they're going to find that John Pryor, because John Pryor has already said that he didn't want this trial until next October 2023, because he would need that amount of time to get his case together. Okay? So he's already complaining about it being in January. That's not going to leave him enough time. So the prosecution really is arguing for the defense here. I think they're arguing for the defense on John Pryor's coattails, not on Lori Vallow's defense team, because Lori Vallow's defense team are saying, we're ready to go. So to me, they are trying to get the judge to make a decision based on Lori Vallow's attorneys not being ready to go. And because she just got appointed a death penalty certified lawyer, because they're going after the death penalty, they're trying to gain some sympathy here on the backs of Lori Vallow's defense team. This here that I just read here to you would be something that you would see coming from Lori Vallow's lawyers, not the prosecution. The prosecution should be ready to go, but I don't think they are. And I don't want to run into a situation where this is going to get dismissed without prejudice too. Because I can see Lori Vallow's attorneys saying, well, we want a dismissal for Lori Vallow because you guys are trying to push us to January 9th. We want her trial. We did not waive the right to speedy trial, and we want her trial in October. So why they're doing this and trying to get the judge to keep these joined, in my honest opinion, I think this is treading on dangerous waters, because she could come back and say, I'm being denied a right to a speedy trial. I want it dismissed. So this is something that you would see her defense team fighting. As noted above, great weight should be attached to the time needed to address the full exchange of discovery, litigation, and all pretrial motions and collect witnesses. Even more true in the case is the voluminous discovery. And further, co-counsel for Lori Vallow Daybell has only recently been appointed, and the time to digest here. Like, why are they fighting this and using this as part of their evidence that they're going to present to the judge in this motion here? this should be Lori's defense team saying, look I was just appointed to this case. I don't have time. They've already said they are ready to go for the October 11th date. So why is the prosecution trying to get brownie points and trying to say and use this statement to have this trial moved to the original date of January 9th? Right? Because I don't think the state can be ready in time. But they're trying to pass it off as they're so concerned about this new appointed lawyer to Lori not being ready on time. And that's just me. I've worked in criminal law for a lot of years, so that's me picking things out that I'm seeing as, they've already said they're ready to go. Why are you putting this in here? They're trying to get brownie points with the judge. Anyway, let's continue. The indictment in this matter alleges 9 counts, with 3 counts of conspiracy and overt acts attributed to both defendants. This is a complex case involving extensive evidence, multiple witnesses. Preparation of the grand jury transcript alone took approximately 3 months. The state has been diligent in reviewing evidence and disclosing evidence to the defense, but there are still items that remain outstanding that have yet to be produced in discovery or are awaiting argument and rulings from the court in relation to consumption of DNA samples. That's not Lori's problem. And I'm not saying I'm on Lori's side at all, you guys. When you bring charges against somebody, we've seen this in the very Morphew case. When you present these charges, you best be ready to go. They have had since 2020, since this happened in 2020, to get their crap together. Again, they're saying that they still have stuff that hasn't been disclosed yet. They're skating thin ice again. We just seen this happen in the Morphew case. They're awaiting argument and rulings from the court in relation to consumption of DNA samples. The complexity of the case weighs in favor of finding good cause for a continuance of the trial date beyond 6 months statutory guideline. No, I don't find they have. My opinion, and I'm just going to give it now. If the judge does not give her speedy trial, I think they're going to run into some problems. The brief continuance of defendant Lori Vallow Daybell's trial also allows for properly joined co-defendants to proceed. Here is the reason for this. Boom. Okay? This is why they do not want Lori's speedy trial date of October 11th to go through, because they want this trial joined and they want it to go ahead in January. The only thing that this is affecting is the prosecution's case to have these joined. This is not, as they just stated what I just read, they're worried about Lori's lawyers not being able to be ready in time. No, they're not. The defense has said they're ready to go, and they're treading on thin ice here. We are ready to go. My client has not waived right to speedy trial. You best have all your ducks in a row, because we want our trial date within the speedy right rules. I don't see anything here that they have given for the judge to say, no, she doesn't have a right to a speedy trial. And they're treading on thin ice here. This is the reason right here why they want her speedy trial rights taken away and this move to January. I don't think Pryor is incompetent. I don't like him, but he's not incompetent. He's a very good lawyer, actually. Just my opinion. So they're saying because of the complexity of the case, blah, blah, blah. They're saying that they have found good cause for a continuance. They have not. And if the judge rules in favor of this, I can see Lori's defense team going for a dismissal. The only reason, the only fight that they have here for the prosecution is they want the trials together. They want one trial. We just seen how much it is going to cost for the prosecution to transfer witnesses and everything and have this done in Ada County. It's astronomical. It's in over $1 million in expenses to have this trial in Ada County. They don't want to have to do that twice. They don't want to have to pay for that twice. That's why they want this to stay joined. That's not Lori's fault. And I believe these both should be put to death. Don't get me wrong. Don't get it twisted. But because I worked in this field for so many years, everybody has their right to their trial. They have a right to a speedy trial. And they have a right to not have that compromise by unnecessary reasons. Now, if the defense says, well, we just got everything and we just don't have time to go through it, we're gonna okay this extension. No harm. But they are adamant about wanting a speedy trial. Yes, Pryor does want them severed. The only one right now that is fighting the severance is the prosecution. And it has nothing to do with the amount of evidence. And, it does a little bit. Okay, we'd have to try it twice, the same evidence being used against both of them, except for certain parts. 90% of the evidence that they're going to present is against both of them. So that's why they're tried together. But when something like this happens, Lori was just arraigned. She has a right to a speedy trial, regardless and aside from Chad's defense. So if they are not in line and one defendant's rights will be taken away to appease the prosecution or the other side, there's a problem. And right now, John Pryor wants this severed. He's made that quite clear. And Lori's defense wants a speedy trial, which brings them to October. So in other words, they are saying we want it severed too. Otherwise, they would have waived their right to a speedy trial and just gone ahead with the January 9th date. You got to look into things deeper. And these are things like if you work in the legal field, you can see these things. Okay? This is why Lori did not waive her right to a speedy trial. That's one way to now they either have to move Chad's trial to October, which from what I'm seeing is being done, so they can have them together, or they've got to move both trials to January 9th, which is the date that's already set, which breaches Lori's right to a speedy trial, or they separate them. Right? That's the options right now. And by the sounds of it, John Pryor is going to fight this because he doesn't want to go in October. They've got a trial date set for January 9th. That's when he's going to go ahead. Lori's team has got a trial date for October 11th, which if you go by them being joined, the prosecution, it's all being moved to October 11th to keep it as one. and within the speedy trial rights of Lori. Chad Daybell waived his right to a speedy trial way back when he was arraigned. So with that being said, those are the three options. Or there's a fourth. Somebody's going to have their case dismissed. Or somebody's going to make a plea. But what I'm seeing here is the court has not, the prosecution has not shown good cause to have Lori's trial put over until January 9th. Not from what I just read. Because the defense has said they're ready to go. What they're saying here and what they're using as the prosecution is using as an excuse is they don't think the newly appointed lawyer for Lori Daybell will have enough time to go over everything. And there are still items that remain outstanding that have yet to be produced in discovery. So they've not produced all the discovery. That's not Lori's fault. And Lori's lawyers have said they're ready to go. So you can't use this newly appointed lawyer as an excuse or finding good cause to have this moved out to January 9th. But that's what they're trying to do. The only reason that they are doing this is because they want to keep the trials joined. Okay, so here, the brief continuance of defendant Lori Vallow Daybell's trial also allows for properly joined co-defendants to proceed to trial in an efficient manner without allowing a type of improper backdoor severance of the cases to occur. And what they're calling by this backdoor severance is that's by Lori not waiving her right to a speedy trial, which means they have to have her in court, in trial by October. They're saying that this is a backdoor method. Well, no, everybody has a right to a speedy trial, and she's put that into effect. I want a speedy trial. This court entered a memorandum decision denying defendant Chad Daybell's request for severance. Okay? Chad wants it severed. In that decision, this court found that joinder of defendants Daybell and Vallow Daybell was proper, and that the defense had not met its burden to demonstrate prejudice requiring a severance. Well, now they have prejudice because now they have a court date, and now that court date is going to have to be moved up even further to October 11th to keep these joined. And the only reason that they would lose their, and this is, I'm speaking on Chad's case, the only reason that they would have to change their trial date that they have set is to compensate for Lori not waiving her right to a speedy trial. This court further determined that a joint trial would serve the interests of justice by providing for judicial economy, procedural efficiency, and avoid possible inconsistent verdicts. So, this is all for the benefit of the prosecution. And what the judge should be finding here is this is not to find the best interests of the prosecution. This is in the best interests and rights of the defendants. As much as we hate it, this has to serve the defendants for a fair trial and a speedy trial if so requested, not to appease the prosecution. If you're going to prosecute somebody, you know you're going to incur expenses to do that. You can't come back and say, well, we want them joined because it's going to cost us too much to try them separate. So let's put their rights aside So we only have to pay for this trial once, is basically what I'm getting from this. That's the only reason. And the fact that they don't want to have to bring the witnesses in to testify twice. And they're worried about inconsistent verdicts. So if Lori is found not guilty in her case, that could affect Chad Daybell's case. That's what they're worried about. But that's not the defense's problem. That's a prosecution's problem if they don't have enough evidence to find her, that the jury finds her guilty on her own. Right? And by all means, you guys, I'm just bringing out what I'm seeing. Okay? I in no way support Lori or Chad. I think they both should get the death penalty. But I'm trying to point out the argument that the defense is going to have, because I did work on the defense side. In my years of working in criminal law, they have nothing here that would warrant, in my opinion, other than this costing the county money and witnesses having to come to trial twice, and the possibility of inconsistent verdicts. Well, if you don't have enough evidence to nail them both either jointly or separately, then you shouldn't have brought this case to court. That's what I'm saying. They're going to argue. A good defense attorney is going to jump all over this. The court's rationale is valid and would be undermined by allowing one joined co-defendant to assert speedy trial as a method of obtaining improper severance early on in a case. She has a right to a speedy trial. A scenario could develop where defendant Vallow Daybell's current assertion of speedy trial results improperly in a premature severance, and then a later basis for continuance is discovered as the case progresses, and defendant Vallow Daybell's waiver of a speedy trial is then entered. At such point, would the trial dates be rejoined? Would such scenario result in further delays? The court determination of good cause to continue defendant Vallow Daybell's trial date for a short period, as proposed by the state, ensures the cases remain properly joined and avoids further complications in the future. So what are they saying there? They're saying, okay, this is a backdoor sever of the cases. So Chad's is going to stay January 9th. Lori's is going to go ahead October 11th. What they're saying here is what they can see, and nobody can say what these lawyers are going to do in the future. But what they're saying is they're concerned that come, say, September, the defense is going to bring a motion for a continuance. They're not ready. So they're going to put Lori's trial out again, which means vacate the trial date that they have set for speedy trial. Because if the defense asks for a continuance, then that 6-month period restarts all over again. So what they're asking here is, if they do that, if they don't go ahead with the court date that they have for trial of October 11th, at such point, would the trials be rejoined? So that's what they're asking here, which I can see, but they don't know that that's going to happen yet. So when you go into court, you can't presume or assume something may happen. You have to go by what you have as facts before you at that time. And it can't be ordered that I don't care what you say, we are going to court October 11th, because the defense could come back and say, okay, we need a motion date for September, we need a continuance. So it's kind of, it's a very touchy and situation, and I can see where the prosecution is getting peeved off. Yes, they cannot force Lori to testify against Chad, and they cannot force Chad to testify against Lori. But if they choose to do that, they can. So if Lori decides, okay, I'm going to testify against Chad, she can. And the other way around. But they can't force them to testify against each other. Right now, K. Mitch, Chad's, I believe I'm going to see some paperwork. I'm watching for it. Right now, both trial dates are now set for October 11th, joined. That's what I believe anyway that's happening here, is they're moving Chad's to October, and John Pryor's going to flip out. Okay, so where were we? Okay, here we were here. So that's what we just said here. The court's rationale is valid and would be undermined by allowing one joined co-defendant to assert a speedy trial as a method of obtaining improper severance early on in the case. A scenario could develop where defendant Vallow Daybell's current association of a speedy trial results improperly in a premature severance, and then a later basis for continuance is discovered and the case progresses. The defendant Vallow Daybell's waiver of a speedy trial is then entered. So that's what they could do at any point before October 11th. So say because of this, they've severed the trials. So Chad goes on January 9th. Lori's supposed to go on October 11th. The cases, if they get the severance on the case. So if that happens, and then say in September, Lori's lawyers file a motion to waive the speedy trial and get a continuance, they want it brought back to January 9th and rejoined, is what they're saying. They're saying that Lori is trying to backdoor the severance, because John Pryor couldn't get the cases severed. So by Lori not waiving her right to a speedy trial, her trial now starts October 11th. They would have to have Chad's trial move from January to October to have them heard together. And John Pryor is not about to let that happen. And that's what they're worried about. But if it is severed, they got their sever, right? So Chad would go January 9th, Lori would go October 11th, but then come September, Lori could say, okay, I'm going to waive my right to a speedy trial. I need this continued. The court's, it's now been severed, so they're still going to be held separately. Adelaide and hers would be rescheduled, another trial date to a later date. And what I think they're trying to do, if you want my honest opinion, which then, if Lori did that, let me stick on that. Sorry, ADHD kicking in. I'm all over the place here. So say the judge says, okay, well, because Lori's has not waived her right to a speedy trial, we're going to sever the cases. Lori goes to court in October. Chad goes to court in January. Okay? Don't forget, John Pryor didn't want the trial in January. He wanted it down in October of 2023. Okay? So this is what I see happening. If the judge does sever these, okay? So Lori goes in October, Chad goes on the 9th. He severs them. I see Lori coming back in September and saying, okay, I'm going to waive my right to a speedy trial. We need months because now we've got all this information that's being piled up. We can't get together a proper defense. We need 6 to 8 months. So now Chad's going to trial in January, and they want 6 to 8 months, which would bring it to May or June of 2023, right? Then the prosecution's going to say, well, we should have kept it joined. Are they going to try and join them again and have the trial date move from January 9th down the road to summer next year, which gives John Pryor exactly what he wanted, right? Because if they rejoin them again, they were separate, then joined. Now they want them separated and then rejoin, separate, rejoin. Like this keeps going back and forth. Like this is a circus. And that's why I've always put up the circus thing. It's a circus. So if Lori then, say in September, waives her right to a speedy trial, and her trial now is set to next summer in 2023, that's going to trigger John Pryor saying, look it. We wanted ours in October. Now they're getting theirs and said, we want it joined again. Or the prosecution is going to say they want it joined. It's just a cluster, you know what, you guys. But I think that this is not just one defendant doing this. I think because then John Pryor would agree to the later date, next summer, instead of this January coming. It's a cluster, you guys. It's a cluster. Okay. So that's why they're saying, if she then waives her right to a speedy trial, at such point, would the trial dates be rejoined? Would such a scenario result in further delays? The court's determination of good cause to continue defendant Lori Vallow's trial date for a short period as proposed by the state ensures the cases remain properly joined and avoids further complications in the future. And what I just explained there is exactly what they're talking about. So the length of the delay that would take place were the court at this conjuncture to find good cause to continue defendant Lori Vallow's trial to January 9th is relatively short. Whether the length of the delay is presumptively prejudicial under Idaho law varies with the circumstances, nature, and complexity of each case, as well as whether under a statutory or constitutional analysis. Idaho courts have determined that judicial review was warranted in several instances in delay of 9 months between complaint and arrest. So the state versus Holtzlander, 42 days after the expiration of the 6-month statutory time period and 1 month delay for trial for summary. However, the U.S. Supreme Court has held that for constitutional purposes, a delay is not presumptively prejudicial. Oh, I can't speak today, you guys. Prejudicial until it approaches 1 year. So they're saying that in these two cases, the U.S. Supreme Court held that for constitutional purposes, the delay that they're asking for from October to January would not be prejudicial unless it's over a year. So the delay from October 11th trial date to January 9th is 2 months and 29 days. As stated above, given the nature and complexity of this case, the interest in allowing adequate time for discovery, litigation of pretrial motions, and the existing of proper joinder of the defendants, such a limited delay is justified and the court can find good cause to allow the joint trial to proceed on January 9th, 2023. Furthermore, this court has granted a change of venue that was brought and argued in defendant Chad Daybell's case. As defendant Lori Vallow Daybell's case was stayed at the time, no argument was made on her behalf as to the change of venue. However, defense counsel for defendant Vallow Daybell stated on the record on April 19, 2022, hearing on the state's motion for the court to allow additional evidence and follow Idaho Code 1918-16 by transporting a jury, that the defendant Vallow Daybell agreed to the venue change and with the court's decision to hold trial in Ada County. So when Chad Daybell had his hearing back in April, the end of April, Rubillard or whatever his name is was there and asked to speak and said that they agreed to the change of venue to Ada County. If that's what the court decided, they had no problem with it. Thus, foregoing a battle like John Pryor has given, trying to battle the change of venue. So this court has determined that in the interest of ensuring a fair trial, a change of venue to Ada County is necessary. The court has further determined that the co-defendants are properly joined for trial. At the hearing on October 19th, extensive testimony was heard regarding the costs associated with holding one trial in Ada County. The cost would be doubled for Fremont and Madison County if the court were to consider holding trials for the defendant Lori Vallow Daybell in October 2022 and the defendant Daybell in January 2023. The court has consistently held and found that these cases are for one trial and that the defendants are properly joined for trial. If good cause is not found to continue Vallow Daybell's trial, and especially if this court considers severing the case by default, there may be need to make a record and determine if defendant Vallow Daybell's previously filed change of venue motion should be granted. No argument or hearing has been held on the defendant Vallow Daybell's motion to change venue, and while the court has scheduled a trial in Ada County for October currently, there is no record in defendant Vallow Daybell's case determining that such a change of venue was necessary or appropriate. So, pre-arraignment delay in defendant Vallow Daybell's case is attributed to the defendant's actions. The foregoing arguments in favor of finding good cause to continue defendant Vallow Daybell's trial date have been in relation to the reason for the delay, which was caused by the defense, and a calculation of the length of the delay from her arraignment and entry of not guilty pleas on April 19th to the January 9th, 2023 trial date. Idaho Code 1935-01 and a constitutional analysis of a speedy trial include consideration of the date from which the complainant or information is filed, an indictment found, or an arrest made. This court has held that Idaho's speedy trial constitutional protection is not necessarily identical to that right guaranteed in the Constitution of the United States and comes into play no later than the time at which the complaint is filed. In the defendant Vallow Daybell's case, an indictment was found and filed with the court on May 25th, 2021. An arrest warrant was served on the same date. The defendant Lori Vallow Daybell, I'm just going to say Lori, had a first appearance on May 26, 2021. However, no further actions were taken because the court was aware of the pending competency order. As noted previously, a stay was entered in the case and remained in effect until April 11th, 2022. Provides that no person shall be tried, convicted, sentenced, or punished so long as the person lacks capacity to understand the proceedings or assist in his or her defense. A request for competency evaluation was filed by the defendant Lori Vallow, previous counsel, and the finding of the competency was adopted by the court in the case. Defendant Lori Vallow was transported to the state hospital in June of 2021 for restoration efforts. The need for restoration efforts and the length required for that is directly attributable to the actions of the defendant. The defendant's actions in any pre-arraignment delay is therefore not chargeable to the state prior to the date the information was filed and was stipulated to by reason and therefore not chargeable to the state. So what they're saying there is it's not the state's fault that this was put off. This falls on the defendant for the delay. Defendant Lori Vallow Daybell has asserted her speedy trial rights. Although Idaho courts have held that where significant good cause for the delay is apparent on its face, there is no need to address the remaining Barker factors. The state will briefly address the remaining 2 factors. So our Supreme Court's non-application of the Barker factors, other than the reason for the delay in Clark and Young, is significant. We take this to mean that where the reason for the delay is well defined and that the reason on its face clearly does or clearly does not constitute good cause, there is no occasion to consider the other Baker factors in assessing a claim violation of Idaho Code 1935. Okay, well, they're trying to split up now factors. You can't, if you're going to use factors in a case where a decision was made based on, say, these 3 factors. So what this means, let me try and break that down for those of you who like it when I break it down so you understand it. If they're going to use and cite a previously decided case, okay, and they say, sorry for the cough, the judge made this ruling because of these factors, okay, and they did. They said factor 1, 2, 3, and 4. These 4 factors were used in that case. If you're going to use that and cite those facts as your reason to keep this joined and move it to January 9th, you can't now come back and say, okay, well, we're only going to briefly address 2 factors of that. Well, you can't, because that judge's decision was based on all 4 factors, not just 2. So you can't use only 2 of the factors that suit your purpose, and the other 2 factors, we want to disregard them because they kind of lean towards the defense. You can't do that. If you're going to cite and use a decision of a case, you have to accept it in whole. Just saying. So the defendant's assertion of his or her right to a speedy trial is entitled to a strongly evidentiary weight in determining whether the defendant is being deprived of the right. Well, one of those factors would say she's being deprived of a right. And those are one of the ones you don't want to use. You can't do that. If you're going to cite a case and use those 4 factors that were used to determine and give that judgment by the U.S. Supreme Court, the whole 4 factors come into play. You can't just pick and choose what you want to use or wording out of a decision that you want to use and disregard the rest. It has to come in as a whole. Anyway, defendant Lori Vallow Daybell is clearly and affirmatively asserted her speedy trial rights as of the date of her arraignment. The bulk of the delay in her case thus far has occurred from indictment and her arrest prior to this assertion of speedy trial. Idaho, the court has found that a delay in the trial setting due to the defendant's request to undergo a psychological examination was attributed to the defendant and weighed against a later assertion of a speedy trial rights. Well, she wasn't arraigned. The clock starts ticking as of the date of arraignment, not the date of arrest. I don't get what they're trying to play with words. It is clear that the delay in resetting the trial for a date prior to October 9th, 1995 was entirely due to McNew's refusal to cooperate in the preparation of a psychological examination, blah, 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 blah. Okay, but she didn't refuse to cooperate. She cooperated in it. So I don't know why they're bringing this in. Okay, and they're just going by this case that was cited, you guys. They're just reiterating what they're taking from this case, where they can't just use parts of it that they want to use. They have to use it in a whole. So the court also determined, and this is in the other McNew case, the court, and these are the two that they want to use, and you can't just pick and choose parts of a decision that you want if it's based on a whole on something. You can't. The court determined that failure to assert a speedy trial well after the 6-month time period had expired, combined with the defendant's request for continuances and the delay in addressing the mental health concerns, indicted that McNew did not necessarily want a speedy trial. But it's not saying whether he was arraigned or not before he asked for this psychological evaluation. You see what I mean? There's information being left out here. If you're asked before you're arraigned, you're found to be mentally incompetent, the clock doesn't start yet. So was this guy already arraigned? And then he said he wanted to... Oh, my God. But they're trying to use that. And they can't. But anyway, they're trying. This court should also consider the time taken to address Ms. Vallow Daybell's mental health concern and the resulting delay to her case in assessing the weight to be given the assertion of her speedy trial rights at this time. Well, she hadn't even been arraigned yet, so she has every right to ask for a speedy trial once she's been brought back to competency. Now, the Mr. McNew, was he already arraigned? You can't just take bits and pieces. Anyway, prejudice to the defendant, Lori Vallow Daybell. The final Barker factor to address is the prejudice to the defendant that arises from any post-arrest delay. Prejudice is to be assessed in light of the interests the right to a speedy trial is designed to protect. 1, to prevent oppressive pretrial incarceration. 2, to minimize anxiety and concern of the accused. And 3, to limit the possibility the defense will be impaired. Internal citations omitted. The third of these is the most significant because it a hindrance to adequate preparation of the defense skews the fairness of the entire system. See, and they're trying to highlight this again, saying the hindrance to adequate preparation of the defense. Well, the defense is saying they're ready to go. So why you're trying to use that, and you're saying it's the most significant, they said they're ready to go. So why are you using this? You're trying to tell the judge that you got to get let's move this to January because having it in October, it's going to hinder the adequate preparation of the defense. The defense says they're ready to go. So that really isn't an issue, but you're using that as the most significant. Defendant Vallow Daybell was served a warrant for arrest in this case on May 25th, 2021. Shortly thereafter, her case was stayed, and she was transported to the custody of the Department of Health and Welfare for competency restoration efforts at a state hospital. While such custody has been deemed incarceration for purposes of awarding pre-sentencing credit, the restrictions on liberty and access to amenities and activities was less stringent than would have been enforced had the defendant Lori remained in the county jail. Further, as noted above, the length of this pretrial incarceration at the hospital was at the defendant's request, and the commitment to a mental health facility was necessary to address competency and other mental health or medical concerns. Well, it's not up to her how long she's held there. If she says she's incompetent, she has a right to have this assessed, and it's up to the mental health medical officials that determine how long she's going to be there. So the way that they're wording this, it's almost like it's Lori's fault that she was there as long as she was. Well, if the mental health professionals have said she's not been brought back yet, that's not Lori's fault. That's, that's just the way it goes. If she was in fact incompetent. Anyway, and usually if somebody is incompetent, which means they're cuckoo, it's generally a mental health issue. So you're basically victim shaming her if she was mentally unsound. because you're saying that basically they're saying she purposely lengthened her stay there because it was a cushion. Anyway, defendant Lori Vallow Daybell time in the county jail in this matter has been limited to approximately 1 month before her transfer to the state hospital and a few weeks since her return following restoration of legal competence. With regards to the second consideration, anxiety or concern of the accused, courts have noted that any criminal defendant will likely be stressed or anxious, particularly when facing serious charges, including murder. Indeed, anxiety by itself is generally insufficient to support a claim of a speedy trial violation. Finally, this court must consider any hindrance or impairment to the defendant, Lori Vallow Daybell's defense. There has been no assertion by the defendant of any impairment to her defense in relation to a delay of the trial. In fact, there are multiple outstanding pretrial motions that have not been addressed. Co-counsel has been recently appointed and discovery is yet to be completed. Certainly, the parties and the court could make extraordinary efforts to address all pretrial litigation, review extensive discovery, and prepare for the logistics of conducting a trial in another county in October. However, such efforts are likely to be at the cost of preparing an adequate defense, not to mention any other cases or defendants that may suffer delay as a result of limited attorney and judicial resources. Again, that's not Lori's problem. Stop crying about the money it's going to cost you. That's not an argument. When you charge somebody and bring them before the courts and have them put in jail, you can't then take away their rights because it's going to cost the county money. And this, to me, you guys, is their whole argument here of moving this trial to January 9th, is what it's going to cost the prosecution, regardless of Lori's rights. And that is not right. They're also using the excuse, not to mention other cases or defendants that may suffer delays as a result of limited attorney and judicial resources. Again, that is not Lori's problem. She has a right to a speedy trial. Hire some more attorneys. Hire more people and resources. That cannot be used to take away her right, anybody's right to a speedy trial, because you're going to be left short in Fremont County. So, and like I said, you guys, I am not saying this because I'm for Lori. I'm not. I believe they both should have the death penalty and be found guilty. But in the same aspect, each and every one of you that live in the United States has this right to a speedy trial. So for the prosecution to come back and say, oh, well, your defense attorneys won't be ready, that's not up for the prosecution to decide. Or for the prosecution to say, well, no, we want it moved to January so we can have it along with her co-accused because it's going to cost us too much money. No. This would be precedent setting if this is allowed. You cannot use, as a prosecutor, how much it's going to cost you and how you're going to be put out and the traveling and having to put up your sheriff and everything in another. You can't use that to take away somebody's right to a speedy trial. You can't. So, what they are wrapping up here with their overall close, however, such efforts are likely to be at the cost of preparing an adequate defense, not to mention any other cases or defendants. No. Without allegation from the defense that there would be an impairment to the defendant Vallow Daybell's defense from the limited delay suggested here. This factor must weigh against the defendant's asserted speedy trial right. Okay, so the factor that you guys are weighing as the prosecution to take away Lori's right to a speedy trial is you are going to decide whether the defense is ready or not instead of the defense deciding. Number one. Number two, it's going to cost you more money to have two separate trials because that's what would have to happen. Because I do believe that John Pryor is going to now fight even harder for the severance and continue to keep his for January 9th. So your fight on this is it's going to cost you more money. Everybody's going to have to go to Ada County for Lori's trial in October just to turn around and have to do it again in January. You can't use this to take away somebody's right to a speedy trial. Weighing the limited prejudice suffered by the defendant to this point, her assertion of speedy trial rights at arraignment against the relatively short length of the delay suggested here, and considering the complexity of the case and the valid reasons to delay the trial, I don't find they have valid reasons. They have not given valid reasons. To delay her trial, this court can properly find good cause to continue the joint trial to the previously scheduled date beginning on January 9th. In my personal opinion, I do not find that they have given valid reasons to delay her trial. The reasons they have given is that they don't think the defense is ready. But that's not up for them to decide. That's up to the defense, and the defense said they're ready to go. Number two, they say, but they don't say it in their close here, that they haven't given all the discovery yet. Well, you've had almost 2 years to get that discovery to them. Here we go, Barry Morphew factor again. That's not the defendant's problem. That's a prosecution problem. And three, you're saying how much money it's going to cost you to do this. That's not a defense problem. So number one, you can't speak for the defense whether they're ready to go or not, which is one of the reasons you've used. The disclosure, that's your problem. And how much it's going to cost you is your problem. Nothing in there is saying that there is a valid reason to delay or take away her right to a speedy trial. She has a right to a speedy trial. She waived her right once she was arraigned. When she was arrested, she didn't get to arraignment yet before they found her incompetent. And if she was having mental health issues, she has a right to that examination. And for her to be kept there as long as she was, I do believe that there was some kind of mental health problem. Could she have exaggerated a bit? She may have. But those people at the mental hospital are pretty smart. She wouldn't be able to fake this for almost a year. So they did find that there was something there. They brought her back to competency. They cannot use that and shame her because of a mental health issue. I don't want to see this get thrown out, you guys. And that's why I'm saying these trials should be separated and she should be going ahead in October. Does the prosecution feel like this is being done backdoored? Absolutely. Could this be a setup? Absolutely. But this gives them reason for an appeal if she doesn't get her speedy trial. That's an automatic right to an appeal. Oh, Rosie, I do too. I think she faked it as long as she could. But I do feel for them to hold her as long as they did, was all of it faked? I think probably 80% was faked. Because, and the reason I'm saying that is to do what she did, there has to be some kind of mental health issue for you to kill your children. Okay? Now, all the other stuff with the beliefs and the portals and it coming to the end of the world, that's the other 80%. I believe 20% or more, there was a valid mental health issue there. Or, 80% mental health issue, with the 20% being the added crap that Daybell put in her head about this cult that I call a cult. There has to be a severe mental health issue to want to kill your children. So I do believe that she already had, before even meeting Chad, I believe that there was some mental health problems. And with him bringing in what he brought in, he was grooming her at the beginning. If you watch the Lifetime movie that came out about it, if that is true as to how this happened, he groomed her right from the beginning. She was infatuated with this guy. But Lori didn't kill anybody until she met Chad. Chad didn't kill anybody until he met Lori. The two together were toxic. And did you guys know that Lori, the reason why Lori hired Mark Means, okay, because Chad had told Lori that they had been married in previous lives. And Lori believed that Mark Means was her child from another time. I don't know if you guys knew that. She thought that Mark Means was her son from a previous life. Huh. It's ridiculous. So tell me that there isn't some mental health issues there. Like, who in their right mind would hire a family lawyer for a murder case? Somebody's not in the right mind to begin with. You know what I mean? For her to even think that what Chad was telling her was okay, she already had mental health issues. And I think the two of them coming together just blew that up. Okay, so wherefore the state respectively requests this court find good cause to continue the October trial date to the previously scheduled date of January 9th, 2023, and prevent any attempt for improper severance of properly joined co-defendants for trial. So let me just see. Let me just see here. Hang on. Yeah, okay. Let me just... Okay, so I showed you Lori, so I'll show you this again for those who are just joining. This is when I had said that I got... a notification that her trial was going to be running. I'm not going to scroll through them all. There's tons of them here that I got. Oh, it's not showing here. Wait a minute. Okay, let's go back. Oh, crap. Hang on. Okay. Why is this bringing me back here? Ugh. Hang on, you guys. I don't know why it's doing this. Hang on. Sorry about that, you guys. Okay, here we go here. Oh, this is peeving me off right now. Hang on. Why is it not opening? Okay, hang on. Okay. This is where I wanted to get to. Okay, share screen. Are you kidding me here? Oh, I see. Okay. That's why. No. Sorry, you guys. Okay, so here's my alerts. A jury trial was scheduled. This is for Lori. Okay, you see Lori's name right here. Lori Vallow. Okay, a jury trial was scheduled starting. Okay, this is showing. You're going to see in this where it starts the 11th month, the 11th day. But this is what I wanted to highlight at Fremont County Courthouse. Okay, now I got this. This is even saying May 3rd, upcoming court event. October 30th, jury trial. Lori Vallow again, jury trial scheduled for 11/28. And you'll see as we go through, this goes right into December. Here's 11/16. It starts on October 11th. But I want to scroll down to, see here again, a jury trial at Fremont County Courthouse. But let me see, scheduled. This goes right into December. 11/29, Fremont County. Hang on. 10. Oh, that was November. Sorry. Here. 31st of October. November 10th. 10/27, which is October 27th. But it does state October. It starts in October. Hang on. 11/11. It's November. Well, let me just go down. It goes right into December, you guys. And there's like over 100 here. There. 10/11. Lori Vallow. October 11th at 9 a.m. Fremont County. But watch. Because Chad's... Let me just scroll to Chad's. Just bear with me. Okay. Chad's, March 13th. This starts when the alert came out. I also got the alert for January 9th. And this is going to go into March. Fremont County, you see this? A jury trial was scheduled for 2023 in Fremont County. Everybody's saying, yeah, put that wrong. Well, that's what I got, okay? That's Lori. Let's go back to Chad again. Chad Daybell. Okay, there's March again. March. Chad Daybell. February. Where is it saying? Fremont County. Chad Daybell again, March. It does state right from January. Hang on, Chad. There's February again, February 8th, Fremont County. They're not in order, you guys, so it kind of peeves me off too, but Chad, February 1st, Fremont County. And Lori's, both of them are in Fremont County, it's stated. Anyway, I don't know if I have to go right back to prove, but there's people out there like, you're lying. It was scheduled. See, February 7th, Fremont County. Believe me, I got over 100 notifications between his and Lori's. I'm trying to get to Chad's where it says the 1st. There we go. There's Chad. January 19th. Fremont County. February 2023, Fremont County. I'm not going to go through it all, you guys. But anyway, that's the Vine messages that we all got. Everybody got. And right now, we just got a whole bunch more for October 11th for both of them. So Vine is, I don't know. I canceled getting notifications there. I'm just going to be watching the court documents themselves because having to go through my email and delete them all is ridiculous every 2 days. And sometimes you get double. Sometimes they send them twice. So I got 400 emails that I've got to delete because I use my email strictly for notifications, like from Vine. But generally, you should get a notification. A trial date for Lori Vallow is set to begin October to December. It should come in one message instead of 100 stating every day that she's going to be in court. But anyway, it is what it is. Right now, hang on. Right now, from what I get from the order that was in court, let me just see if I can find it here for you, and I will show you. Oh, this is all over the place. Hang on, you guys. I think it's this one. Let me hang on. Okay, here it is here. Okay, so just a few days ago, this came out. I'll share it. Okay, so back in April 19th, the state filed a motion to reconsider the court's decision to transfer the trial to Ada County, and they lost. This is 10 pages, you guys. I'm not going to go through the reasons why the court denied it. It's been denied, but I will go through these parts. Hang on. Okay. As to why the judge denied it. Okay, hang on. Let me just go to the end here. It is ordered that it's going to be held in Ada County. But there was in his decision here. See, unfortunately, this is where I say I think Lori's going to get her wish with severing the trials and having her trial in October, because unfortunately, okay, so his decision unfortunately led to increased costs, bringing it to Ada County. That concern cannot override the other factors that this court has considered. Now, those factors, in full consideration of the factors the court must determine in deciding whether justice will be served in transporting a jury. The court cannot conclude that the state has met the burden persuading the court to exercise its discretion of transporting a jury. While the additional costs have been considered carefully, the persuasive media coverage concerning this case related in the court's initial determination that the trial would be transferred to Ada County in order to reasonably ensure the impaneling of a fair and impartial jury. But also with this was a consideration of a fair trial. I'm trying to find it. Okay, so the first major concern of the court entails ensuring that Daybell is protected in his 14th Amendment right to due process, including the right to a fair trial. So, if he's not going to deny the severance because, or the transfer, because they're protecting Daybell's 14th Amendment right to due process, including the right to a fair trial, they're surely not going to let them move Lori's trial to January against her constitutional right to a speedy trial. Okay? I feel the right to a speedy trial is just as important as right to due process, including the right to a fair trial. They're both equally as important. They're a right. So this is why I say I don't think that, based on what they've said, and they're using the excuse that it's going to cost them more money. The judge has already denied that as an excuse in the Chad Daybell matter. So I can't see them denying Lori's right to a speedy trial because of the cost of having two trials, or, letting them go against her right to a speedy trial. I just can't see it. So I don't know what's going to happen. We're going to keep an eye on it, you guys. I will keep an eye on that. He didn't deny Chad Daybell's rights to due process and a fair trial by moving it back to Fremont County. They did move it to Ada County. I can't see them changing any of his rights there. And moving him to October would be another infringement on his rights to due process also. So, I mean, there's a lot that's going to be fought here, you guys. In my honest opinion, they should have the two trials. But that's just my opinion. I can't see how the judge can protect Chad Daybell's rights without doing the same for Lori Vallow. And I feel that it would be an appeal, a major reason for appeal, if they took her speedy trial away. And I don't think it's going to go over, or I don't think John Pryor is going to agree to move it to October when he's already complaining that he doesn't have enough time now, having it in January. It's going to be a cluster, you know what? Circus is going to begin again. So, with that being said, let me just check. I wasn't watching a lot of the chat, you guys, so if there was any super stickers or super chats put in, please let me know in the chat so I can give you proper recognition for that. Let me just scroll back here. I can only scroll back so far. So if you did, it is very much appreciated. So let me scroll back here for some questions. It is insane. And what I found funny is they were basically saying that the defense isn't going to be ready in time, blah, blah, blah. Well, they're not the defense. They have no way of knowing that. So to use that as a reason to move her trial is ridiculous. Okay, thank you, Rosie. Okay, so Good Grandma says, okay, let me just go back over to my other screen then. Good Grandma says the right to a fair and speedy trial precedes a joinder trial. That's right. So if they have to separate the trial, will it affect the evidence? No. It's not going to. What the prosecution is complaining about now is now that the judge has said it's going to be held in Ada County, it's going to cost them like $1 million. Okay, that comes out of Fremont County's budget because there's a lot of things that they're still going to have to pay for, even though it's being held in Ada County. So, with that being said, they don't want to have to do this trial twice based on the same evidence. That's why it was joined at the beginning. Okay, because they said that the same evidence would be produced at both trials. So that's why it was joined. But now that it's been joined, there's a trial date set for Chad for January 9th. Lori has now become competent and she has the right to a speedy trial. Her date has been set to October 11th to start, which she's entitled to. The same evidence is going to be used at her trial as what's going to be used in Chad's trial. The only difference in evidence that's going to be used is Lori is charged with defrauding the government for getting income for JJ and Tylee, which she wasn't entitled to, whereas Chad is not charged with that. And then there's a separate charge just for Chad, where he claimed a life insurance policy on Tammy that he was not entitled to. So there's two separate charges for each of them there. As far as I'm concerned, that those charges should be separated from the murder trials, so they could be tried separately, which would be a slam dunk if they're found guilty anyway. So I feel that those charges may be dropped, but the government may want to pursue it. So those should be separated from the murder charges. Also, Lori is facing another murder charge in, is it Indiana? She's facing a murder charge in another state for the death of Charles Vallow. I don't think she's been arraigned on that yet. Chad and Lori are both charged in the death of Tammy. All right, let me share this. Arizona, thank you, Nana. Lori is also charged in Arizona. The charges are pending in Arizona for the death of the murder of Charles Vallow. Okay, so here is, I didn't realize she'd been charged. Yeah, here it is right here. Okay, so this is in the District Court of the 7th Judicial District of the state of Idaho in and for the county of Fremont. Notice of intent to seek the death penalty for Lori Noreen Vallow, aka Lori Noreen Daybell. The murder of Tylee Ryan, the murder of JJ Vallow, and the murder of Tammy Daybell. The murder of Tylee Ryan was exceptionally heinous, atrocious. The murder of JJ Vallow was especially heinous, atrocious. The murder of Tammy Daybell was especially heinous and atrocious. She is charged with the murder of Tylee, JJ, and Tammy. Yes, she is charged with the death of Tammy also. And they are seeking the death penalty. Yes, Charles, thank you. Charles, and she's also going to be facing the murder charges in the death of Charles Vallow in Arizona. Thank you for that, you guys. Yeah, she was. It's right now, good grandma. I think it's going to weigh on if she gets the death penalty in this case. They may have it anyway. I don't know if they're going to decide to have a full-blown trial for Lori in the murder of Charles. I don't know what's going to happen there. I think Arizona is probably going to execute the arrest warrant, but she will be tried after this trial. So if she's found not guilty in the deaths of her own kids, she's still facing another, and I think that's why it's still sitting there. If she's found guilty in the deaths of JJ, Tylee, and Tammy, and she's sentenced to death, I don't think they will go ahead with that other murder trial for Charles Vallow, because it would be kind of, I don't want to say a waste of money and time. They may go ahead with it anyway, just to have it on record that she is guilty of that too. And it's all going to depend, I think, on this trial here, because she could appeal this. And if they don't give her due process of a speedy trial and they force this to go ahead in January, that's a right for an appeal. She could win her appeal. They don't want her walking the streets free. So they may go ahead with that trial anyway. So she would be transported to Arizona for that trial after this one. That is not true. That is not true. John Pryor wanted the trial in October of 2023. So this 65 hoopty is not true. So one of the mods, please remove that comment. I don't want anything untrue being posted here. I have followed this since day one. He did not want the trial for Chad until October of 2023, and the judge said, no way, it's too far out. That's when they put it for January. And he says, I can't possibly be ready in time for that, or with all this discovery and blah, 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 blah. Hang on, you guys. I'm just trying to get my chat in order here. I don't know why this isn't. Okay, just give me a second, you guys. Rosie, can you see that message from 65 Hoopty in chat? Because I can't see it on the YouTube studio. Okay, thank you, Rosie. Because I can't even see it, so they must have me blocked. It comes up on my StreamYard, but it's not coming up on my YouTube. Did you block them, Rosie? I didn't want the person blocked. I just wanted the message deleted. Please don't block people unless they continue. Okay, let me go check because I can't see it at all. And usually I can see messages that were deleted unless you've blocked them. So let me just go and check because I don't want people blocked, just messages unless they continue. Let me just go and make sure that they haven't been blocked. Just Sherry says it says message deleted. Well, I'm not seeing it at all, so they must have me blocked. Can one of the other mods still see the person? Okay, Mitch, can you still see? Okay, never mind. I can see. I didn't say she was going to walk free, you guys. Yeah, I just seen that they commented. I just wanted to make sure that Hoopty wasn't blocked. Okay, so let me get back to this. Hoopty says, I thought the prosecution asked for it to be later in 2023, and John Pryor asked for it to be no. It's the other way around. John Pryor did not want the Chad's trial until October of 2023. He was actually at the beginning saying 2024, and they said absolutely not. And then he said, well, we should be ready to go by October of 2023. And the judge said, absolutely not. And he said it. That's when they set the January 2023 date. It's the prosecution it's the other way around there. The prosecution wanted to go ahead this year. And John Pryor said, no, he wanted October 2023. So the judge came to the middle and said January. Right now, good grandma, I don't think Pryor is playing any games. He's got a trial date now that he is working towards. Guys, I'm telling you, John Pryor wanted it in October of 2023. The prosecution wanted to go this year. They wanted a trial date for 2022. And the judge says, I'll find a happy medium. And that's when the judge set for January. And go check. I'm telling you. I wouldn't lie to you. Yeah, there's games being played all over the place. But right now, John Pryor has a date for January 2023. And I do believe that I covered that. Grand jury was held to save the evidence from the witness testimony. Yes, they do that often because anything that the grand jury does is under seal. And it's also to protect the evidence too. Because if you got somebody who, say, passes away before they can testify, they've got that witness's testimony from the grand jury. You're welcome. Let me just go over here. Lori and Chad. Oh, let me get that. Hang on. What's that? Okay. No, not that. Okay. Court orders. Joni B, he wanted October of 2023. I have a document on my screen right now where he waived his right to a speedy trial. Hang on. Let me share this. Okay. You see here? August 20th, 2021. Defendant's waiver statutory right to a speedy trial. Chad Daybell. Okay? This is where he's waiving his right to a speedy trial. Okay? This was signed on the 19th of August, 2021. Now, what I'm trying to find, let's fact check. Because I'm telling you, I know this case inside and out. This was signed in August. 2021. He wanted a court date for October 2023. I'm going to find it. Believe me. I'm going to find it. Just give me a minute. I think it was actually in a live. 2020, hang on. Oh, it's Lori. Hang on, I'm going to find it. I'm going to find it. But I do believe that it was in a live. I will find it, you guys, and I'm not going to waste all my time here because I know what it is. That's Lori. Hang on. I will find it. Sister, since you are here. No, I was... Hey, I started this 8 o'clock. I knew you wouldn't be up and ready. November... Yes, October 2023. I know I have it here. Just, I will find it. Because I have them all. Okay, let me just go into their court dockets. Because, Lori and Chad, here we go. If you'd see my things that I got to look through, you guys, you would be... September, February... Okay, screw this. I'm going to go... Hang on a sec, you guys. Let me just scroll in here. I will find it. Let me look at December. Well, I'm looking at the December 2021 notice of trial setting final pretrial conference and order governing further proceedings. This was in this is nothing in here about it. This is just the setting of it because the judge decided it was in a live. And I will find it. Let me see what this is. I think it could be in here. I don't know. I'm just briefly running through this, you guys, looking for that date. Because what they argue about in court, when they're live in court, isn't all put into the filings. But I do very much remember in court, John Pryor saying that he wanted a trial date for 2023 October. And I do believe that it was in a live. Yeah, it's not in there either. Anyway, I would have to go back and find it. Yeah, so good grammar. Hi, Des. I agree that Pryor tried to get October 2023. Yes, he did. But it was denied. The prosecution wanted to go late this year, and Pryor said no, he didn't have enough time, blah, 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 blah. He wanted October of 2023. The judge said that's way too far out, and that's when the judge set it for January 9th. So, and I know that for a fact. The motions hearing, I worked in the legal field too, Joni. This has nothing to do with what, neither one of us were there at this. But what I'm saying, go watch the December 2021 motions hearing. I'm going back to block myself. Okay, whatever. The motions hearings are important. But when they put it onto paper and the order is filed, he doesn't say John Pryor fought, he wanted. No, that would have been said in the courtroom. And I watched every one of them. And John Pryor wanted October of 2023. And the judge said no. The prosecution wanted it to go the end of this year, 2022. So the judge went in the middle and he gave a date of January. And I never said that the motions hearings were not important. Motions hearings are very important. But when we watched it live, it happening in court, John Pryor wanted the trial set for October of 2023. Not 2022, 2023. And the judge said, absolutely not. That's too far out. On my channel, where is it? Content. I'm searching. Okay, let me see here. Okay, you guys, give me a second. Okay, hang on. I gotta get my earbuds in. Hang on a sec. I think I found it. Hang on a minute. Hang on a second, you guys. Just give me a second, you guys. I'm trying to find it. Just give me a second, you guys. Hang on, you guys. Bear with me. I think I found it. Just give me a second, you guys, because I'll play it for you. Okay. Now, I can't seem to find that exact. I can't find that exact one, you guys. That was all on Lori. I tried listening to a little bit of it to see if I could get where they were saying what they were saying, and I couldn't find it. But anyway, it's my recollection that I thought it was. So I'm going to say I'm going to say I'm not sure now. Until I can find it, I'll say I'm not sure. But I was remembering, and maybe you guys can all maybe clear it up. From what I can remember, it was John Pryor that wanted it set in 2023, and the prosecution didn't. They wanted it sooner. Des may be sleeping. I don't know where she's here. Okay, so sorry, I'm going back in chat here. Sister says she didn't sleep good last night. Oh, well, that's why I didn't message you this morning. So I don't know, you guys. I'd have to go back and watch all the replays to see. But as far as I remember, I think it was John Pryor that wanted it. But I could be wrong. Des driving to get her meds. Okay. What do you guys remember? Do you guys remember it being the state or John Pryor wanting to set it out? Okay, who was it in here? Joni B seems to think it was the prosecution. She could be right. I don't know. I remember it as John Pryor wanting it set out. But like I said, Joni B could be right. I could be wrong. Joni B says, you weren't nice about this. What are you talking about? I said I would go and check it. As far as my recollection, like I said, Joni B, I just said, you could be right. But as far as my recollection is, it was John Pryor that wanted it set out. Like I said, I can't find it. I'm not going to have everybody on hold here while I'm trying to look for it. But I said I could be wrong. It could have been the other way around. So if you took it like that, I am sorry. But you could be right. I don't know. I was just remembering that it was John Pryor, and it's like, wow, really? Because I know Lori Vallow's lawyers are saying they want to go now. They don't want to wait until 2023. They want to go now. So, like I said, you could be right. I could be remembering wrong. I will check it. I will find it at some point in time when I got some time. JP wanted to set it from watching. It was a motion but denied. Which one is that, Grandma? Yeah, see, some people are saying it was the state. Some are saying that it was Pryor. But as far as I remember, and like I said, I could be wrong. We've got a balance here. Some say it was JP. John Pryor wanted to set it from watching. It was a motion but denied. Okay. Joni, you know, I don't need this. I'm not going to have a pissing match with you. I'm saying, as far as I recall, it was John Pryor trying to set it out for October. If I'm wrong on that, I got no problem admitting I'm wrong. But that is the best of my knowledge. It was him. You fought people. Now you say it was Recollection Tune. Like, piss off. I'm gonna sit here. I just took like 20 minutes trying to find it. Like, I don't know what else you want me to do. Like I said, and I've got people in here thinking the same way, and I've got people saying it was the state, and I got people saying that it was Pryor. Because, Joni, I'm not going to keep arguing with you about this. And I'm going to say it right now. I believe I'm right. But if I am wrong, I will admit I'm wrong. Until I can find that, I'm going to stick with what I said. If that's not good enough for you, I'm sorry. I even went to the subscribers to ask them what they recollect. One says the state along with you, and others are saying Pryor. Like, geez. Want me to cut off my right arm for you? All right. Like, holy crap. Anyway, so I'm going to watch for the filings for Lori Vallow and see what's going to go on there. There is a new hearing now that has been set for the 19th of May for Lori. It's a motions hearing. So I'm going to be assuming at that time they are going to fight to have their case move ahead for October. I don't feel that the state has in their filing that we just went through today. I don't think the state has made a good argument. They are basically saying it's because it's going to cost them more money and they're going to have to use their witnesses twice. I don't think John Pryor is going to want to go ahead October 11th, but that's yet to be seen. I'm waiting to see if he has any filings, and then we'll take it from there. So is there any other things that you guys want to ask or bring up regarding the Lori Vallow? And we're still waiting to you guys to hear back on the Letitia Stout thing to see if she's had her competency stay completed yet. I think they've set that out to June 9th for hers to come back with all the paperwork. I think they were saying for her it was going to take a couple weeks. Hey, Leland. There's Leland. How are you feeling, my dear? I hope you are feeling better. We're just about to wrap up. Oh, thank you, Rosie. I appreciate that. Yeah, I am. I'm watching because I don't think it should take that long with the Letitia Stout, however you pronounce her name. But they're saying that to get the report and everything written up, they would want a few weeks, up to 3 weeks, once her evaluation is done to get the paperwork all in order. So I believe that it's June 9th. She's back. Oh, and you guys, Trezal West is coming up too. Trezal West has a readiness hearing on May 13th, and Troy Drivers has a preliminary and pretrial hearing on May 10th. And Sherry's opinion. Pryor keeps pushing it back. Yeah, but that's his job. Yeah. It's like we may not agree with everything that they're doing, but they are doing, they're there to work for their client, right? So it's like, even though we don't like it, it is what it is. Aww. Everybody's saying, hey, Leland. You're very welcome. Yeah, treatment yesterday, not feeling, oh, well, I hope you feel better. Yeah, the West case, Trezal and Jacqueline are going for a readiness hearing on May 13th. And the Troy Drivers, that was Naomi, or the Walmart parking lot thing there. He's going for a preliminary hearing on May 10th. So I don't know if we are going to be able to see the Troy Drivers one. They're pretty sticky on showing theirs live. So I don't know about that one. And the Giselle and Jacqueline West, we're going to see what happens there too. And yeah, the Letitia Stout one, I'm anxious to see that one. Barry Morphew's back in court again on May 26th, where he's facing those charges for filing that, or putting in the ballot where he voted for Trump for Suzanne. He's back in court for that. And I don't know, you guys, I haven't really heard about the trying to influence an official. I know they had and the gun charge too. I know they had separated those 3 charges from the actual murder charges. So I don't know if he's still going to be going for those yet. I haven't heard. And then Trezal and Jacqueline West's trial is supposed to start on May 23rd. So, and Lori Vallow is back for motions hearing on May 19th. So a lot coming up. Yeah, that one there is so sad. I'm anxious to see what's going to happen with the pretrial readiness with them. It gives them the chance to see all the evidence that is against them. One may decide to flip for a deal. Who knows? I have not, Leland. I have not heard anything about that one yet at all. So as soon as I hear anything, that one I'm trying to keep an eye on the best I can. But as soon as I hear anything, I will. Yeah, that is sad. I did do a read on it, and I feel that the mother could be missing too. So we're going to have to keep our eyes on that one too. If anybody hears of anything, just shoot me an email. Let me know. And then we can go over it. Okay, you guys. So that's that for this morning. We'll keep an eye on all these cases and see what's going on. See if Lori Vallow gets her wish and gets these trials severed. We'll have to see. Okay, so with that being said, thank you everybody for being here, for following along. Thank you for my mods for always being here. This will probably be unavailable for about 20 minutes once the live ends for me to get all the information and that into the description and whatnot. So give it about 20 minutes if you're just joining once the live ends for it to be available again for you guys to all rewatch. Jean says, well, I hope Barry gets minimum of probation for felony voter fraud. I hope he gets more than that, but we can only wish, right? So yes, if anything else pops off, you guys, I will jump up here. Take care of yourselves. Stay safe. Thank you, mods, for being here and doing an awesome job as usual. I appreciate each and every one of you. So until the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.